Hello, everyone. Thank you so much for joining. We're going to get started in just a few minutes. We're still seeing some folks trickle in. Thank you. Good afternoon, everyone. Thank you so much for joining us today. We're still seeing folks trickle in, so we're just going to give it a couple more minutes and then we'll get started. Good afternoon, everyone. If you just joined us, we will get started in just a couple of minutes. If you'd like, you can go ahead and introduce yourself in the chat. Thanks. Okay, why don't we get started? It's a couple minutes after 12, so I'm sure that people will still trickle in, but we want to be mindful of everyone's time. So good afternoon, everyone. Thank you so much for joining us today. We're so happy that so many of you could join us. If this is your first time coming to one of our webinars, welcome. And if you attended the webinar that we had back in October or one of our past webinars, we want to thank you for returning. This webinar today is an overview of how to start a case in New York Family Court. And we encourage you to check out our other webinars like the one we did back in October, where we cover the basics of different topics like child support and custody. Recordings of all of our webinars, including this one, will be on our YouTube page. And we'll put the YouTube link in the chat. At the end of the webinar, we'll be sharing information on how you can receive a copy of the slides that you see here today as well. So first, just quick introductions. My name is Jessica Stadmeyer, and I am the Director of Legal Resources and Community Engagement at Family Legal Care. I'm also one of our attorneys on staff. And now I'll pass it over to my colleague, Molly Burke, to introduce herself.
Hi, good afternoon, everyone. Thank you so much for joining us. My name is Molly Burke. I am a staff attorney here at Family Legal Care, as well as the Advocacy and Policy Advisor, and I will pass it over to Evany, who is going to help us today as well.
Hi, good afternoon, everyone. My name is Evany Morel. I'm a program associate here at Family Legal Care, working on our helpline. Thank you all for joining us today.
Thank you, Molly and Evany. So before we get to the presentation, you may have heard by now that we have a new name. We are no longer Lyft and are now Family Legal Care. All of our programs and services, which we'll go over today, have remained the same. But as we mentioned during our last webinar, we are excited about our new name, Family Legal Care, because we think it better conveys who we are, what we do, and the heart of our mission, which is really to provide compassionate support and care to families who are going through the New York State family court system, and ultimately to help increase access to justice. Just a couple of housekeeping items before we get started. We really want this webinar to be interactive, so here are some ideas of how you can participate. If you haven't already done so, please take a moment and introduce yourself in the chat. We've seen that already some people are doing that, which is great. And throughout the presentation, we'll be asking a series of poll questions. We would love to hear from you. We'll save time for questions at the end, but as we're going through the presentation, feel free to submit any questions that you have to the Q&A button at the bottom. And feel free to send us a chat if you have any comments or concerns that come up during the webinar. Evany will be monitoring the chat. If you need closed captioning, we put the link for live streaming in the chat, and we also have ASL interpreters available here. If you're not able to view them on video, you can change your view to gallery view to be able to see all of the panelist videos. Okay, so now to our first poll. All right, so what brings you here today? Please take a moment and select the option that best represents you. Just give it a couple more minutes. I see people are still answering. Okay. So it looks like we have a really nice mix of people here today. We have a lot of partners and advocates looking to help clients, which is great. We have a couple parents or caregivers, and then we have some people who are just interested in learning about family law. So thanks for participating, everyone. Okay, so this is what we're going to cover today. First, if those of you are not familiar with Family Legal Care, we're going to briefly go over our programs and services and how to get in touch with us if you need some support. After that, we'll give an overview of the New York family court system and who can file different types of cases in family court. Then we'll cover where you can file your case and how that process works. Next, we'll go over serving court papers. And that's the process for notifying the other party about the case. And finally, we'll give some tips on preparing for your first court date. As we're discussing these topics, I just want to note that all of the material covered today is intended to be legal information only and not advice. As I mentioned earlier, we encourage you to submit your questions using the Q&A feature below, but you may hear us tell you to contact our helpline or speak to an attorney for more specific information, and that's because everyone's situation is different, so what applies to one person may not apply to everyone. So let's get started. First, we're going to give an overview of who Family Legal Care is and what we do. If you're not familiar with our organization, our story goes back all the way to 1996, when a group of 3 young lawyers recognized that there was a real need in the New York family court system for people to get basic legal information. They set up a folding table in the Manhattan Family Court and stationed themselves there to answer questions and offer guidance to anyone who needed help. Our organization has really grown since then, yet our mission remains effectively the same: to increase access to justice for families in New York Family Court. And how do we do this? So we offer parents and caregivers free legal information and advice, as well as easy to access resources and technology to help them navigate the family court system here in New York, not just in New York City, but all over the state. Our helpline gives information about New York family law and family court procedure, as well as referrals by phone, email, and live chat. Most of our helpline staff are bilingual, and we can also serve other languages besides English and Spanish through an interpreter line. Our helpline is also an entryway to our services. So if someone's interested in meeting with an attorney like myself or Molly, which I'll discuss in just a moment, our helpline associates will conduct a screening to see if the person is eligible for a consultation and will schedule that appointment. Our general helpline hours are Monday through Friday from 9 to 5, though we close for lunch from 1 to 2. The phone number for the helpline is listed here on the slide, 212-343-1122, and you can also access our helpline on our website. We're going to put this information in the chat as well. Family Legal Care offers limited scope representation, and this means that we have a team of staff and pro bono attorneys who meet with unrepresented parents and caregivers for 1-hour consultations by phone or by video. Unrepresented means that they do not already have an attorney representing them in their case. The level of support the attorneys provide during these consultations depends on the case and the litigant's needs. And when I say litigant, what I'm referring to is someone who has a case in court. But please note that we do not provide any representation. So in other words, the attorneys cannot speak on a client's behalf in court. And I think I saw a question in the chat about whether our services are just New York City only. And so what I'll just say is we can provide consultations, and all of our services are really for anybody, no matter where you live, as long as it's a New York family court case. So even if you lived in, say, Pennsylvania, if you're dealing with a New York family court case, you can still reach out to us and get information and assistance. Examples of what our attorneys can do are providing legal advice on next steps, helping litigants prepare and file petitions or motions, and advising people on how to effectively represent themselves in court. Depending on the case and the litigant's needs, our attorneys may also be able to provide follow-up consultations and support. So again, if someone you know is interested in a consultation, or if you are interested in one, you can visit our website to learn more or reach out to our helpline. And then it's also important to note that we do not have any income requirements for our services. For a consultation, the only requirements are that the litigant is not already represented by an attorney, and that the case is one of the types that you see listed here. And then, as I mentioned earlier, that the case is in New York. So it's a New York family court case. We provide consultations on paternity and parentage, child support, custody, visitation, and guardianship of minors. We can also advise people on domestic violence issues, such as how an order of protection impacts custody and a visitation. However, we do not provide advice solely on orders of protection. We also do not provide advice on abuse and neglect proceedings or ACS cases, nor on divorce, which is handled in Supreme Court. Family Legal Care also offers over 60 original legal resource guides, which provide step-by-step information on a range of New York family law topics. The guides are available in 9 languages and can be found on our website at familylegalcare.org/guide. You can search for guides here by topic, language, and location. Family Legal Care recently launched a digital justice initiative to address gaps in the New York Family Court's online resources. At our tech hubs, litigants can access technology and receive assistance to attend virtual family court hearings, download and submit family court forms, and navigate the online court system. Currently, we have 3 tech hubs located in Brooklyn, Queens, and the Bronx at the addresses you see here. The Brooklyn Tech Hub is open by appointment only, but the Queens and Bronx Tech Hubs allow both appointments and walk-ins. To make an appointment, you can send an email to techhub@familylegalcare.org or call 496-0046. And you can go to any tech hub that's convenient for you, whether or not you have a case in that county. And then I'll just quickly mention 2 more resources that we offer. Through our new Family Law Navigator tool, parents and caregivers can answer questions about their particular family law situation and are given a detailed customized report with next steps they can take, including links to forms and petitions to fill out. This tool is available on our website. And then lastly, also on our website, we have links to common court forms, including our guided court forms. This is a free program that walks you through completing certain family court forms, and it walks you through in very simple language that's easy to understand. At the end, the program will generate a completed document in PDF format that is ready to be filed with the court. Our guided court forms and Family Law Navigator are really great tools, and they're all designed to simplify the court process, so we definitely encourage you to check them out. All right, so that's an overview of family legal care and the programs and services that we provide. Just to reiterate, all of our services, again, are completely free, regardless of your income. You can always visit our website, Family Legal Care, to learn more. And Evany will be putting all of that information, including the phone numbers, in our chat as well. So next, I'm going to pass it over to Molly for an overview of the New York Family Court System.
Thank you so much, Jessica. So welcome, everyone. We're going to start with a brief overview of family court in New York and talk about what types of cases that New York Family Court hears. And then we're going to jump into who can file in each of those types of cases. So in New York, the family court hears and decides certain types of cases, such as the ones that you see listed here. And the ones in green are the types of cases that family legal care attorneys can advise on. So paternity and parentage, establishing the legal parent of a child, custody and visitation, where you're looking at physical and legal custody, child support and spousal support, financial support provided to a child or to a soon-to-be ex-spouse. Now, please note that family legal care can assist with spousal support cases when there's also a child support case. And like Jessica mentioned earlier, family legal care attorneys can only provide advice on domestic violence cases when they interact with another case listed here, like child support or custody and visitation. And we also assist with guardianship cases, but there are many different types of guardianship cases, and they can be heard in several different courts, like surrogates court, Supreme Court, and family court. Now in family court can only hear or decide cases involving minor children, meaning under 21, when there's no property involved. There are also cases for guardianship in family court that involve immigration matters, such as special immigration juvenile status cases or SIJ cases. Now, we're not experts in immigration matters and will not be discussing those types of cases today. Now, guardianship cases can be extremely complicated, so you should speak to an experienced attorney if you have any questions about filing for guardianship or determining whether family court can hear or decide your case for guardianship. Now, we go into these cases in more detail in some of our previous webinars, so be sure to check them out for a more in-depth look at each of these types of cases. But today, we're not looking at what the court is considering when they're making a determination about each of these types of cases, but we're looking more at the process of getting you into court on these types of cases. So let's talk about who can file a petition. Some cases, only government agencies will be able to file for or start their own case on, such as child abuse and neglect cases or juvenile delinquency cases and the other cases listed here. And what this means, for example, I cannot go into family court and ask to start a child abuse or neglect case as an individual. These types of cases are brought by ACS or CPS, government agencies. But in other types of cases, individuals are the ones to file or to start the case. And our webinar is focusing mostly on these types of cases. So paternity and parentage, child support, custody and visitation, some types of guardianship, and orders of protection. Now you'll see here that some of the cases or some of the types of cases are starred. And that just means that a government agency may also be able to file, but we're going to talk about each of these cases in a little bit more detail, and I'll let you know when government agency might be able to file in those types of cases. So let's start with orders of protection. There's civil orders of protection and there's criminal orders of protection. Civil orders of protection are heard in family court, and these are known as family offense petitions or family offense cases. Now, in family court, there must be a relationship to be able to file for a family offense in family court. What this means is that there has to be a relationship by blood, for example, cousin or brother, or relationship through marriage. You have to have a child in common, have a child together, or you must have been in an intimate partner relationship to be able to file in family court. Now, if there is no relationship, or if your relationship falls outside of these other categories that are listed on the left, you may still be able to get an order of protection from criminal court, but you would need to speak to the DA first. But if you're in need of an order of protection, you should really speak to a domestic violence or DV organization for assistance and reach out to our helpline team for a referral. Now let's talk about parentage. As a reminder from some of our other webinars, parentage is an incredibly important step to starting your case in family court. It needs to be legally established before any child support, custody, or visitation case can be heard. So who can file? Any biological parent, the child's guardian or caretaker, or any other person who is caring for the child in a parental relationship can all file for parentage. An intended parent can also file. In 2021, an act called the CPSA was passed that allows parents to establish parentage even if they are not the biological parent of their child. So for example, in instances of gestational surrogacy, the person who has donated sperm, an egg, or embryo, as well as the person who is acting as a surrogate, can also file. Now, the Department of Social Services, or DSS, can also file for parentage, but they can only file when a child is receiving public assistance, such as cash assistance or rental assistance. This is an example of an individual and a government agency being able to file in the same type of case. So now, who can file for child support? You can file for child support if you are the legal parent, you're the child's caregiver, or Department of Social Services, DSS, again, when a child is receiving public assistance. Now, if your child is receiving public assistance, you as an individual are not allowed to file for child support. DSS will be the ones to file. And it's important to know that you can also file for child support even if there's no custody order. Now, we often get the question, can I file to put myself on child support? And the answer is maybe. You can try to file, but the parent or caregiver who has physical custody has to consent to you being on child support through the family court. And a jurist could also consider what's in the best interest of the child in these circumstances. Now let's talk about who can file for custody, visitation, and guardianship. Who has standing or the right to file for custody? Any legal parent, meaning parentage has been established, and anyone else who has an important role in a child's life can also file, but they may need to show that there are extraordinary circumstances in order to have that legal right to file. For guardianship, it's the same as for custody, but you're really looking at a non-parent caretaker, not a legal parent. And visitation, who can file for visitation? Any legal parent, again, any grandparent or sibling, a grandparent and child sibling is more limited, and the court is going to look to see three things. First, if there's a reason why the visitations are not happening through the parents. Second, that there's an established relationship between the relative and the child. And third, they're always going to look to make sure that it's in the best interest of the child to have this visitation with this relative. So now that we know the types of cases heard in family court and who can file, we're going to talk about jurisdiction and venue, really looking at where to file your case. But first, we want to see how much you already know about jurisdiction. So first, jurisdiction, what does jurisdiction mean? A, I have no idea what you're talking about, which is absolutely okay. That's why we're here. B, a court's authority to make decisions in a case. C, jurisdiction means the courtroom. Or D, the process for selecting a jury. And I'll give it just another second. Okay, let's have the results. Yes, a lot of you are right on it. Jurisdiction means having control over something. And for a court to have jurisdiction, it means that the court has the power to make a decision about your case. Generally, the court has jurisdiction or power to make a decision about a case when there's some sort of relationship to your case. So for example, let's say that a child, Alice, lives in California with their mom, Betty. Alice's father lives in Florida. In this situation, if anyone were to file in New York does not have any relationship to this case. No one lives in New York, and there's no other information about the child in New York. So a New York court would not have jurisdiction or the authority to make a decision about this case. For custody and visitation cases, the courts will generally follow what's known as the home state rule. This means that you will file in the state where the child has lived for the past 6 or more months. Now, if the child hasn't lived in the state for the past 6 months, or if you have a newborn, you could file where they have lived previously for the most amount of time or most recently. And the reason for the home state rule is so that the court has relevant information regarding the child or any other information related to their school, any additional caretakers that they may have, medical information, and any other relevant information to what is going on in this child's life. Now, a court can take emergency jurisdiction, meaning they can make a decision about a case even if the child has not lived in the state for the required 6 months. This can happen only in certain circumstances, like if the child is in danger or if there's a domestic violence situation in certain circumstances. Now let's talk about where to file for parentage and child support cases. For these cases, you can file in the state where either parent lives or resides, or where the child lives or resides. But keep in mind, the court will still need what's called personal jurisdiction over the other person that you are filing against. And this means that the court will need to see that this person, not just the type of case, has some sort of relationship with the state. So let's use Olivia and James as an example to understand personal jurisdiction. So Olivia lives in Michigan with her and James's son. Olivia files for child support in Michigan where she lives, but James lives in Connecticut. James has no relationship to Michigan and has never stepped foot in Michigan. The Michigan court may not have personal jurisdiction over James because of this, even though Olivia is allowed to file in Michigan. So does this mean that Olivia can never file for child support against James? No. Put in the chat where you think Olivia could file for child support. And remember, for a court to have jurisdiction, you can file where the child lives or where either parent lives. Yes, I'm already seeing the right answer. Olivia may have to file against James in Connecticut, where he lives, for child support. So now that you've determined which state is the appropriate state to file in, how do you determine where within this state you file? This is known as venue. Venue is the specific court that you want to file in, and it's generally looking at the specific facts of the case to determine which specific court to file in. It can also be determined based on where you or your child lives. Oops. We're going to use Xavier and Ben to help us understand venue better. So Xavier and Ben have a son, Oliver, and Oliver lives with Ben in the Bronx. Xavier lives in Queens. Ben wants to file for custody. Now, because all 3 of them live in New York State, New York has jurisdiction, the power to hear the case. But which family court in New York would Ben file in? This is venue. So for custody, visitation, and guardianship cases, while you can file in the county where either parent lives, venue is generally appropriate where the child resides, specifically the county where the child lives or resides, because that is more likely where the facts of the case are. So in our example with Xavier and Ben, Oliver lives in the Bronx with Ben. Ben or Xavier would file in the Bronx family court for custody, visitation, or guardianship. For child support and parentage cases, venue is appropriate in the county where either parent or the child lives. So again, in our example with Xavier and Ben could file for child support against Xavier in Queens, where Xavier lives, or in the Bronx, where Oliver and Ben live. Essentially, this comes down to jurisdiction, which state you're filing in, venue, you're looking at which county to file in. So now I'm going to hand it back over to Jessica to talk about the filing process.
Thank you so much, Molly. So we are going to start this section with a poll. All right, so true or false, you must have a lawyer to file a petition in family court. Just give it a few seconds. All right. So most of you are correct. The answer is false. You do not need a lawyer to start a family court case. We will talk a little bit later about how you may be able to get a lawyer after you've started a case, but if you do not yet have one, you still have the right to file. As you start the filing process, here are some key terms to know. The first is petition. A petition is a document that tells the court what you are asking for. In order to start a family court case, you must file a petition. There are different types of petitions for different types of cases and requests. For example, there is a petition to start a new custody case, and there are petitions to modify existing orders like child support or visitation. When you file a petition to start a case, you are then known as the petitioner. The respondent is the person or agency against whom you are filing. A summons is a legal document that provides notice to someone that a case has been filed against them. The summons will include the time, place, and date your case will be heard. As the petitioner, you are generally responsible for making sure that the summons and a copy of your petition are served on or provided to the other party. We will explain what this means a bit further in the presentation. Another term you may hear about as you start a family court case is pro se litigant. Pro se means that you are representing yourself without a lawyer, and litigant, as we mentioned earlier, is a person involved in a court case. And finally, you may hear the term jurist. In New York Family Court, a jurist is a judge, referee, or support magistrate, depending on the type of case you have. They have the authority to make decisions in your case. There are a couple of ways to start the filing process. You can start online, where you can obtain court forms from the court's website, or you can also complete the court's DIY program online for certain types of cases. If you choose either of these options, you will still need to provide a completed petition to the court, either by mail, through one of the court's online filing systems, by email, or in person, depending on where you are filing, because every court is different. If you're not sure, contact the court directly to find out your options for filing. We also encourage you to check out Family Legal Care's guided court forms, which we mentioned earlier. If you start your case by going in person to the court, most courthouses have a petitions window. Here you will find court staff who will provide you with a petition form that you must fill out to start your case. Just note that court staff cannot give you legal advice. And then here you will see some sample petition forms. If you go in person to file a petition, note that the court may provide you with a different form. In general, however, these forms will ask you for information about yourself, the respondent, and your child or children. Once you have completed your forms and turned them in, you will wait for your papers to be processed. If you are filing in person, the court will typically process your papers that day. If you are filing electronically or by mail, you will need to wait for the court to process your papers and provide you with the court date. Every case gets its own identifying number, known as a docket number. The docket number begins with the letter representing the type of case you filed. For example, if you filed a custody or visitation petition, your docket number will begin with the letter V, as in visitation. For most types of petitions, you will not see a judge the same day. Rather, you will get a court date to return. The types of situations in which you may see a judge the same day are if there is an emergency. Let's say you have a child that you believe is in danger and you cannot wait a lengthy period of time for a court date. Another situation is if there has been domestic violence and you are requesting an order of protection. After you've submitted your forms, the clerk will tell you next steps. You may receive a typed petition and summons that day, or those papers will be sent to you by email. Before you leave the court, be sure to confirm how you will receive the court papers. And note that if you filed online, keep an eye out for an email with these documents. Whichever way you receive the documents, be sure to read them carefully because they will explain when and how you should submit other documents related to your case, such as evidence. In certain situations, the court may serve the papers for you, but most of the time you will have to arrange for these papers to be served. In addition to the summons and copy of your petition, the court should give you a document called an affidavit of service, which will be completed by the person who serves the court papers. We'll talk a bit more about service in just a minute, but before that, I'm going to go over some tips for filing. The first tip is that if you are filing in person, you want to arrive early. You may have to wait in line to get through security, and you also have to wait for your papers to be processed. You want to make sure you have enough time to complete this process. In other words, be ready to spend some time in court. The second tip is that whether you are filing in person or online, you want to be prepared. Make sure you have any relevant documents you need. These documents can include copies of your child's birth certificate, a marriage certificate, and photo ID. These documents will help facilitate the filing process. You also want to review all of your papers carefully. This includes not only the petition that you are filing, but also any papers you receive back from the court. You want to make sure you know what papers should go to the other party, what papers will be for you, and what papers you have to return to the court. And of course, reach out to us, Family Legal Care, if you have any questions about the filing process. There may be a Family Legal Care staff member in the courthouse that day if you're going to one of the courthouses in the 5 boroughs. And if not, you can always reach out to our helpline. Remember, just to reiterate this again, because it's important, you do not need a lawyer to start a family court case. However, if you're in the middle of a case and already have a lawyer, you should talk to that lawyer before filing anything. And now I'm going to talk about how to serve court papers. Once you are scheduled for a court appearance, you must now notify the other party about the court date. This process is called service. Generally, you'll need to serve only when you're filing a new petition. The first thing to know about service is that you cannot serve the papers in your own case. Also, anyone who is a party to the case may not serve the papers. For example, if you are filing for child support, neither you nor your child can serve the court papers on the other parent. So who can serve? You have a few options. First, anyone over the age of 18 can serve. This can be a family member, friend, or anyone else who's willing to help you out. If you don't have someone who can serve the papers for you, you can also try a process server or the sheriff's office. Both will do service for a fee. And now it's time for our last poll. So in general, when must court papers be served? A, within 48 hours after you receive them from the court. B, at least 8 days before the court date. C, at least 2 weeks before the court date. Or D, any time before your court date. Just give it about 10 more seconds. All right. So I can see that we stumped a couple of you here. So the correct answer is actually B. For most family court cases, papers must be served at least 8 days before the court date. So how exactly do you get these papers to the other party? In general, the courts require personal service. This means that you must have the papers handed directly to the other party in the case, which again is known as the respondent. The court does have fairly strict rules about service, so if the papers aren't served correctly, your case may not go forward. And note that the other party can be served almost anywhere, including their home, school, or work. And then as we saw from the poll, the papers generally must be served at least 8 days before the court date and can be served any day of the week except Sunday or a day of religious observance that the respondent follows. As always, there are exceptions to these rules. So in child support and parentage cases, service by certified mail is allowed. However, note that if the respondent does not come to court on the first court date, the court may direct you to serve the respondent by personal service. Also, in certain situations, like with orders of protections or in an emergency, the court may allow you to serve any day of the week and up to 24 hours before the scheduled court date. If the court gives you specific instructions on how you ought to serve, make sure you are following those instructions as closely as possible. Once the papers have been served, whoever has performed the service will have to complete the affidavit of service. An affidavit of service is a document that shows the court that the respondent was served in the correct way. Remember that this document must be completed by the person who served the papers, not you, the petitioner who started the case. So here we have a sample affidavit of service. The top portion will be completed by the person who has served the court papers. This will be their name, address, and date of service. For example, if Molly served my child's father, John, with court papers, Molly would put her name and address here at the top. For the next part, she would fill out information about when and where she served John, as well as what papers she gave him. The next section will have information about who they served and a physical description of that person, which in this example is John. And note that if I was serving someone by mail, Molly would instead have to complete the third section here. And then finally, at the very bottom, you'll see that this document must be notarized by the person who served the papers. In other words, Molly must bring the affidavit of service to a notary, have it notarized, and then give it back to me. The petitioner, which again in this example is me, will need to provide this completed notarized document to the court, usually during the first appearance or the first court date. This paper is proof that the other party knows about the case. Again, proof of service is required in order for your case to move forward. Otherwise, anyone could file a case against you and you would never know. So it's important to make sure that this document is filled out accurately. Sometimes things may not go exactly as planned. So what would happen if the other party won't take the papers, for example? If the respondent refuses to take the papers, the person who is serving them can notify them that they have court papers and then leave the papers at their feet. What if you cannot find the respondent or have not been able to serve the papers before your first court date? You must first make reasonable attempts to find or serve the respondent. You can give the judge a written list of different ways that you tried to find and serve the other party. These efforts at service are called due diligence. The list should include the ways in which you tried to find the respondent, as well as any dates, times, and places at which you tried to serve the respondent. Places can include a home, place of work, or school. If you show the judge that you made sufficient efforts, the judge may give you a new court date, which is called an adjournment, to give you more time to serve the respondent, or the judge may allow you to serve the respondent another way. This is known as alternate service. Alternate service is when a judge allows you to serve someone another way besides personal service or certified mail. One of the most common examples of alternate service is known as nail and mail. This means attaching the papers or nailing the papers to the front door of the respondent's last known address, as well as mailing a copy. Other examples of alternate service may be serving someone who works with or lives with the respondent, or serving that person via social media or text. The most important thing to know with alternate service is that this is only allowed if the judge says it's okay. So you must follow the judge's instructions carefully. And let's go through some tips for service. So first, make sure you keep track of all your attempts. Like we mentioned earlier, if you're unable to serve the respondent, this tracking will be important in terms of making sure that you're able to move forward with your case. You also want to be resourceful. Even if you're not exactly sure where the other party lives, you can try asking a family member or a friend or someone who is still in contact with the other party. You can also try to serve them at places that are outside of their household. You also want to make sure the affidavit of service is filled out correctly by the person who served the papers and that it's notarized. As we discussed earlier, this is a very important part of your case to make sure that it can continue. And the last tip is always reach out to us, Family Legal Care, if you have any questions or need assistance. You can call our helpline, or you can read through our legal resource guide on how to serve court papers. We also have a free guided court form on our website that walks you through completing that affidavit of service. After answering a few simple questions, you will have a completed PDF version of the affidavit of service that you can then print and have notarized by the person who completed the service. So visit our website at familylegalcare.org to learn more. And now I'm going to pass it over to Molly.
Thank you so much, Jessica. So now you have decided what you're filing, where to file, you filed your petition, and you've served the papers on the other party, the person on the case. Now you have your first court date. Let's talk about what happens. First, do you appear in person or virtually over Microsoft Teams? And appearing just means showing up to your court proceeding or hearing. You're going to want to look on your notice or summons that you receive from the court. This should say either in person or virtual. If you would like to appear in person instead of virtually, you should contact the family court before your court date and let them know you'd like to appear in person that day instead. If you're appearing virtually, it will be over Microsoft Teams. Be sure to log in early. If you're even 30 seconds late, your case could be dismissed or they can move forward without you there. If you have any trouble logging in, look at your court papers again and call the number that is listed there for assistance. You can also call into your court proceeding to let them know you're having difficulty logging in or to appear by phone. If you are appearing in person, you will want to check in with the court officer or clerk outside the court part. So what happens when your case is called? A case being called means that it is time for your hearing. You will see or go before a jurist. Now, calling cases goes back to pre-pandemic days when all cases were in person and you would be sitting in the waiting room outside of the courtroom and someone, usually a clerk or a court officer, would come out with a list and call or announce the parties that were up to see the jurist. Now, it could be the same thing in person or with virtual cases. It just means that you're being let into your virtual courtroom. So the first thing that happens when your case is called is that the jurist will want to make sure that the other person was served properly before they can move forward with your case. Now, remember, like Jessica was mentioning, the jurist cannot move forward without the other party being properly served. They need to make sure that the other party was notified properly about your case. Next, the jurist will want to make sure that everyone who is supposed to be there is there. Anyone who is supposed to be there is a necessary party. So for example, if a non-parent caretaker is filing for guardianship, they must be sure to serve both legal parents of the child. The legal parents are the necessary parties. After the jurist discusses service and makes sure that all necessary parties are there or have been served, the jurist will ask if you would like to see if you are eligible for a court-appointed lawyer or if you would like time to adjourn your case and hire or speak with a lawyer. Now, please know that court-appointed lawyers are not available for every type of case. So child support cases are generally not eligible, for example. And eligibility for a court-appointed lawyer depends on the type of case as well as on your financial eligibility. It can help to submit proof of your income to the court so that they can determine if you're eligible or not on that first court date. Now, if the jurist does not ask you about an attorney, you can also ask them to see if you are eligible for a court-appointed lawyer. If anyone asks for a lawyer or for the opportunity to hire a lawyer, the case will be adjourned or postponed. Now, finally, after the jurist determines everyone was properly served, all necessary parties are present, and they've discussed attorneys, everyone has hired one or has had the opportunity to speak to one, you will then be able to discuss your case and your petition. This is where you should be prepared to explain your case simply and clearly. Why did you file? Why are you there? What are you looking for? You may not be able to discuss this during your first court appearance. However, you should always be prepared to discuss this. Now, please know that family court cases generally take at least several court hearings before a final order and decision is made, which is why the case will likely be adjourned or postponed to another hearing date. So if you cannot attend the court date, you may be able to ask the jurist for an adjournment before the court date, essentially asking the court to postpone your court date. Sometimes this is done by filing a motion, but you'll want to check with the specific court on how they'd like you to ask for an adjournment. You will let the court know why you cannot make your court date, and the jurist will make a decision on the day of your original hearing whether or not to grant or allow your adjournment. The jurist can make an order without you present, without you there. This is called a default order, and generally this can happen if you are the respondent. Now, if this happens, you can file a motion to vacate the default order or a motion to recalendar. A motion to vacate the default order means you would file a motion asking the court to get rid of this default order or cancel it. A motion to recalendar is asking the court to reschedule your court hearing. If you are the petitioner and you do not appear, if you're the one who started that case and you do not show up or appear, the jurist can also dismiss your petition, which would require you to file again. But you might be able to file a motion to recalendar asking the jurist to reschedule your court hearing. But please know that what you file and why can have procedural consequences to your case, so you should speak with an attorney before filing anything at all.
Great. Thank you, Molly. So that is the end of the formal part of our webinar. We wanted to leave a lot of time open for questions. So if you have any questions that you haven't yet submitted, please do so now using the Q&A button at the bottom. At the very end, we'll be sharing a link to provide feedback on this webinar. We would love to hear from you on what went well today, what we can do better in the future, maybe what you'd like to see future webinars on as well. And I know some people were asking about this, but we will send you copies of the slides from today's presentation as well. We also just wanted to give everyone a reminder of how you can get in touch with us, whether you have follow-up questions from today's presentation that you maybe didn't think of until after this ended, or if you need some support with your family court case, or maybe you have a client who could use our support, or if you just want to learn more about what you do, or what we do, at Family Legal Care, you can reach out to our helpline by phone, email, or live chat. The number again for our helpline is 212-343-1122. Our website is familylegalcare.org, and please follow us on social media. Okay, so let's open it up to questions. Ebony, did we have any questions submitted to the Q&A?
Yes, we received a few questions so far. The first is, how can a litigant obtain free legal representation for a guardianship case?
That's a really good question. So like we spoke about, you might be able to ask the jurist on the case, either a referee or a judge, to see if you're financially eligible to be appointed a lawyer to represent you. You can also call Family Legal Care for us for a free consultation. Like Jessica was mentioning at the beginning, we can advise on guardianship cases, but if you're looking for representation in court, you can start by asking the jurist on that first court date.
And what I would add to that, Molly, is it's only legal parents who can request a lawyer to represent them in custody, visitation, and guardianship cases. So let's say, for example, if a grandmother is petitioning for custody or guardianship of her grandchild, she's not eligible for a court-appointed lawyer, even if she met the income requirements.
Really good point. Thanks, Jessica.
Great. And our next question is, how can a parent request a reduction of monthly child support payments, and what is the process to request an adjustment?
So that would be filing for a modification petition, or it would be filing a modification petition in family court where your order was entered. I would say start by calling us or going to the family court and asking for a modification petition to start the process.
And we have a legal resource guide on our website that's specifically about how to modify child support orders. So it goes over the different grounds or reasons that you may be able to get a modification and the process to do so. So definitely check it out there as well.
I love that LRG. I give it
yeah,
to
it's a great one.
Almost all my consults.
All right, so in terms of custody, many parents cannot obtain a US passport unless they have custody of the child. What type of custody should clients request in that situation? And is this also the case when the absent parent is outside of the US?
I believe it's the same process, but it's sole legal custody. Legal custody is the decision making over a child's life, meaning major life decisions like medical, religion, passports fall under there as well. For one parent to obtain a passport, you're looking at sole legal custody.
Thank you, Molly. And the next question is, what happens if a parent has sole custody and the children are refusing to visit with the non-custodial parent?
It's a really good question. And I hate to say that it depends, because every family court case is unique and every child is unique. So every situation is different. I generally do have to say it depends. What I would say is give our helpline a call and see if you're eligible to sit down for a consultation. We might be able to discuss in this particular instance what could happen, and in your situation, what to do next, or what's happening and what could happen in court.
And I can just add just a couple of examples of
Yeah.
what a parent may do in this sort of situation. So the custodial parent or the non-custodial parent could file a modification petition to say that they want to change something in that custody order and visitation order if there is one in place. And if the non-custodial parent feels like maybe the other parent's not complying with that court order and that's why they're not having visitation, the non-custodial parent can also file a violation petition, which is also known as a petition for enforcement, to let the court know that that court order is not being complied with. But like Molly said, these situations can be really dependent on what's going on in that particular family. So definitely reach out to us if you want to talk through your case.
Regarding the last portion about virtual appearances, someone asked if you could repeat the portion about being late. Did you say that if a party is 30 seconds late, the court can cancel the appointment or move forward?
Yes. So unfortunately, if you're even 30 seconds late logging in, the jurist on your case could move forward with the case, or they could dismiss your case entirely, leading you to either file one of those petitions, either file a new petition again, or file one of those motions that we talked about earlier. If you're late, call the family court, or if you're having any difficulty logging in, call the family court. That's why I say log in early. If you have any tech concerns, or if you're worried about logging in or appearing virtually, you can call the family court and ask to appear in person, or I would also say reach out to our tech hubs and we might be able to set you up and help you appear virtually.
Okay, we had another question. You mentioned that if somebody files in person, that they can get a court date that same day, or they would get notice of their court date that same day. Is this in specific courts?
So they wouldn't necessarily get a court date that same day, but they may be able to get notice of their court date. It depends on the court. Often what I'm seeing is that the courts will email the petitioner, whoever filed that case, about when their court date is after they already leave, but it all depends on the family court. So if you're going in person to file, ask the court clerk when you're filing what the process is and what you can expect about getting notified about a court date or about your court date.
Right. And just to expand on that just a tiny bit more. So another way to put it is that typically you're not going to see a judge that same day that you file a petition, unless it's those situations of an emergency or you're filing for an order of protection.
Is there a way to request for a magistrate to make a decision on a child support case that has been going on for 2 years and has been dragged out by the other party in the case?
Possibly. You might be able to ask the magistrate to make a decision, but again, we're going back to it depends, and it depends on the case. What I would say is give us a call, see if you're eligible for a court consultation. There are certain things you might be able to ask for. But yes, there may be a way, is what I'll say.
We have one question about orders of protection. Someone asked, for cyber incidents, what kind of cyber harassment or cyber stalking is enough to file for an order of protection?
Hate to say it again, but it depends. Reach out to a domestic violence organization, domestic violence specific organization to get help, not only with maybe filing for an order of protection, but they might be able to help you
I think Molly may have cut out. So yeah, we'll put that information again, Ebony, if you don't mind, in the chat just for some domestic violence service providers. So that's really kind of the best sort of situation to go to them for if you do have specific questions about whether you in your particular situation might qualify for an order of protection. But you can always try to file that petition and then see what happens. Ultimately, it is up to the judge to decide.
Okay, we have one more question. What can you do if the other parent that gets joint custody has a mental health condition? How can the parent get full custody in that case?
Am I back? Can you see me and hear me? Okay, great.
Yes, you're back. Thanks.
Thanks. So again, it depends, but for custody and visitation cases generally, the court is always looking at what is in the best interest of the child, and that really varies based on every situation, every family, every child. But some of the things that they'll look at are who's the primary caregiver. They'll look to see about the stability of the child. They'll look to see about each parent's relative fitness, mentally, physically, everything. So that may come up when a jurist is making a determination. For how it could specifically come up or how to get custody in that case or sole custody in that case, unfortunately, that's legal advice and that's not something that we can provide over a webinar, but we could provide it in one of our legal consultations. So again, call our helpline and see if you're eligible for consultation with one of our attorneys like Jessica and myself.
And someone asked if there will be another seminar about family legal care.
So I can answer that. We have different recordings of webinars we've done in the past on our YouTube page. So if you go to youtube.com/family legal care, and we'll put that in the chat, you can look at our past webinars. The one that we held in October was just on New York Family Court Basics. So we covered our services, but then also covered custody, visitation, child support, paternity, and just the basics of family law topics. You can definitely check those out. And then our legal resource guides are really great resources just to cover basic information about different family law and family court topics. And you can find those on our website. Thank you, Ebony, for putting all that information in the chat. So go to familylegalcare.org/guide to view all of our guides, and you can filter by topic and language and location as well.
Agreed. We have so many great resources on our website. So I want to especially plug our website to go there for some of our resources like Jessica, you were mentioning.
And then while we're waiting for maybe any last minute questions, Molly, if you can just turn to the very last slide.
Yes.
We have a link here for a feedback survey. We would love to hear from all of you and get your feedback on how today's webinar went. So if you want to see anything again in the future, a webinar topic that we didn't cover here today, or if you want to give us any feedback on what we could have done better, we would love to hear from you. This really helps us grow our program and improve our services. And like we said, if you want to share this webinar with anyone else, or maybe go back through and watch anything again, we'll post this on YouTube later today or tomorrow. So you can check out our YouTube page and feel free to submit any other questions. We did schedule this webinar a little bit longer just to give people plenty of time to answer or to ask questions. So feel free to add some more questions in the Q&A or in the chat if you have them. We'll stick around. But otherwise, thank you again so much for coming today. We really enjoyed interacting with you all, and we hope that this was helpful, and we hope to see you again at future presentations.
Thank you all.
We did have one question come in.
Sure.
Do you host workshops for clients in Spanish?
We do. So we have done it in the past. So typically what we do with workshops is we will partner with an organization to provide a workshop directly to like a program or the participants in that program. But we are exploring doing webinars and other presentations in Spanish in the future as well. We've done an Instagram live event a couple times in Spanish. So we definitely do Spanish outreach because we understand that Spanish speaking people don't have a lot of information and resources. And we want to make sure that they're getting all of the information that they need to be able to navigate the court system as well. So thank you for raising that question. And absolutely, we're looking into it. So we appreciate it. Any other questions? This is your last chance. Okay, it seems like that might be it. So we don't want to keep you all. Thank you so much again for attending. And please do fill out that feedback form if you can. We would love to hear from you, and we hope to see you all again very soon.